Hi, my name is Josef and I'm presenting What About Precedent and Information-Theoretic Analysis of Common Law. It's a joint work with Tiago Pimentel, Niklas Stoehr, Cotterell and my supervisor here at University of Cambridge, Simone Teufel. We started this work to address a question that has been bothering lawyers for about 100 years, which is how does precedent operate? Precedents are a crucial component of legal reasoning. In common law countries, new law is created via precedent, but in continental legal system, precedent is also valuable as it carries a persuasive quality to future outcome prediction. We have a little diagram here to explain the idea a bit more clearly. A case can be broken down into its facts, its arguments, and its outcome. In the arguments, the judges will cite previous cases and they will use them as part of their argumentation to reach the outcome, given the facts of the case. But the question is, what about the precedent is actually used or imported via the citation? Is it the facts of the case or is it the arguments? This is what we'll be tackling in this paper. And we'll be doing it on the ECtHR, European Court of Human Rights case law, which consists of about 12,000 labeled cases, which we have split into facts, arguments for this purpose, and also extracted the different citations from the arguments in order to be able to carry out our experiments. But just to give you a little more background about how law utilizes the precedent, these ideas can be traced back to the discussion between Halsbury, or rather the intellectual conflict between Halsbury and Goodhart, who have a completely different opinion about which one, whether an argument or a fact, affects the outcome. And surprisingly, both have raise a very good point. Arguments intuitively seem like the answer, because law is a system of rules that are applied to the facts. So surely the arguments developed by judges is what informs the outcome decision. Well, the problem with that perspective is that in reality, a lot of cases don't contain any argumentation. They are just the facts and outcomes. And this is what Goodhart in 1930 pointed out and claimed, therefore, that it must be the facts. That while there is argumentation in cases, really the true legal argument is developed in some sort of reasoning by analogy way. And the arguments themselves are secondary importance to the facts of the case, and we should focus on those. So at this point, probably a good time to look at what facts and arguments look like. We have a little example here. Facts are really sort of these factual circumstances of the clients. As you can see here, the applicants DP and JC, who are sister and brother, where they live, where they were born, etc., etc. Argument, on the other hand, imports the legal aspects. So here we start with Article 2. The convention provides, and there's a definition, and then that definition will be related or not related to the facts, and there'll be sort of justification for it. So arguments sort of explain the legal position. So this has been part of a legal discussion for a long time. And the answer to the question has never been resolved because it's very hard to quantify which part of the legal document has persuasive power. How does one measure that? Those were until recently fairly impossible to formalize questions, and this is where we come in with operationalization of the tests via an information-theoretic framework. And it is very simple. We propose the Halsbury test can be formalized simply by measuring the mutual information of the outcomes given the arguments of the precedent cases and the facts of the case at hand, which is what we do here. And we can measure this very easily because we can just compute a cross entropy. This is how we approximate entropy here of the outcomes given the facts of the case at hand, and subtract from it the cross entropy of the outcomes given the Halsbury, which is the arguments of the precedent cases and the facts at hand. And here's a visual analogy for that process. Of course, we can then go and compare that to Goodhart's test, which is the same, except instead of looking at the arguments in the precedent cases, we look at facts in the precedent cases. And now we can measure how much mutual information is contained by each perspective, by each legal perspective. So, what did we find? Who was closer to the truth? Well, we find that precedent arguments do give us nearly 58% more information about the outcome of the case than the information contained in the facts of the precedent. So it seems like Halsbury's view is more widely used in the domain of European Court of Human Rights than Goodhart's. However, there are caveats to this. So, first of all, we find that there is this interesting tendency of judges relying on either the precedential facts or arguments depending on the legal article or the law in question. You can see on this table, not every time the Halsbury's view, purple here, outperforms Goodhart's view, the pink view. So what is taking place? Where does this play in law? We believe that the reason for this is that judges are not necessarily completely certain how more abstract laws operate in every circumstance. So when we have an extremely wide law construct, like let's say right to life, which is very hard to pinpoint and define, we observe that judges in fact do rely more on facts. They are wary to codify perhaps the reasoning as part of arguments because they are not entirely sure perhaps what would the legal test be for a law which is just very all-encompassing. And in our paper we trace this trend over all the different articles, and we discuss how this conceptual uncertainty affects the way the judges rely on different parts of the precedent. Perhaps more importantly though, these results are only relevant for the European Court of Human Rights. However, the methodology that we introduced here can be, in theory at least, applied on any legal system. So there are good candidates where one might try to conduct a study like ours, for example, on the large American legal data sets or British legal data sets, both common law countries, precedential systems, but also the level of granularity or the question asked with this sort of information-theoretical toolkit could be very different. We don't have to ask a question decide between Goodhart and Halsbury, but perhaps instead we can investigate what type of argumentation is employed more or less by different legal system or different legal actors. This would be particularly relevant to the more closely annotated Japanese cases, where we have arguments zoned into different categories of argument. So one could conduct a study of of those there as well, or conversely, there's a data set for the House of Lords judgments in the UK, which would be another good candidate for this experimentation. So we hope that our work will perhaps inspire some further research in those areas. The key takeaway for us here, though, is that indeed arguments do matter, and this is really important within the context of legal outcome prediction, which is a very popular task within legal AI at the moment, but it is usually defined as predicting the outcome given the facts of the case, which makes perfect sense because the arguments are in a way an answer to the question that the facts pose in legal terms. However, utilizing the precedent as part of training in some fashion should clearly be the way of improving performance of these models, since that is indeed what judges do as well. I hope you take time to read our paper and see for yourself the details of our implementation. All our code is available online, both the models themselves and the labeling or the extractive process to obtain arguments and precedent from the ECtHR dataset. Please reach out with any questions. I'll be very happy to answer and let me know what you think on Twitter. Thank you very much, and have a good day.